Welcome to our presentation. We are Group 8 from the module Legal Skills and Methods under Dr. Suzanna. The topic we are focusing on is statelessness in Malaysia. Statelessness may sound familiar to you all. Some may know, some may not know. Some have heard of it, but can't just put their finger on what statelessness is in Malaysia. So, let me, Shami, and my group members take you on a journey to know what statelessness is in Malaysia. According to the 1954 Convention relating to the status of statelessness persons issued by the United Nations High Commissioners for Refugees, UNHCR, establishes that the legal definition for stateless person as individuals who are not considered citizens or nationals under the operation of the laws of any country. In simple terms, this means that a stateless person does not have the nationality of any country and is not considered as a national by any state under the operation of its law. Some people are born stateless, but others become stateless. The majority of stateless people were born in the countries in which they have lived their entire lives. Statelessness often have a severe and lifelong impact on those it affects. The millions of people around the world who are denied a nationality often fight for the same basic human rights that most of us take for granted. Often, they are being denied a legal identity when they are born, access to education, healthcare, marriage, and job opportunities during their lifetime, and even the dignity of an official burial and a death certificate when they die. Many pass on statelessness to their children, who then pass it on to the next generation. According to the United Nations High Commissioner for Refugees, UNHCR, there are at least 10,000 people in the West Malaysia alone who are denied nationality, with an unknown number in East Malaysia. These people aren't allowed education, jobs, healthcare, housing options, and protection. More often than not, these communities are treated as unwanted foreigners or left to fend for themselves. According to the Development of Human Resource for Rural Areas (DHRRA) in Malaysia, there are 7 categories of statelessness in Malaysia. The first one is person who arrived or born before independence, that is 31st August 1957 or Malaysia Day, 16th September 1963. The second one is person rendered stateless by gender unequal provisions in nationality law. There are 2 sections under this category: children born out of legal wedlock to Malaysian father, or another one is children born to Malaysian woman overseas. Moving on, there is also abandoned children and foundlings, and stateless adopted children. Next is mobile and semi-nomadic Sama Bajau. Next is indigenous people, also known as Orang Asli or Orang Asal. And the last is multi-generational migrants and refugees. Our group would like to focus on talking about the abandoned and foundling children and the stateless adopted children, which both fall under the category of stateless in Malaysia. So, why does statelessness exist in Malaysia? There are a few reasons for these issues. The first one is lack of documentation of the child, for example, birth registration and birth certificate. The second one is the child is birthed to stateless parents, and so they become stateless. Next one is the procedural problem during the route applying for citizenship of the child. Some applications take a long time, and the application may be rejected for no reason. Now, I would like to tell you a little about stateless abandoned children and foundlings. I will tell you a little short story about abandoned and foundling children in Malaysia through their point of view. I'm an abandoned child. I grew up in a government home. I was issued my green IC, my caste, which I have to renew every 5 years, and I'm unable to apply for citizenship. I can't apply for citizenship. I can't even apply for blue IC. Police sometimes says my green card is a fake card. Here are some information on my caste. The temporary resident identity card or my caste is issued under Regulation 5 Clause 3 of the National Registration Regulations 1990. This indicates the expiry date and must be renewed within 5 years, and the color is green in color. After hearing this story from their point of view, you can see that this is the harsh reality for abandoned and foundling children in Malaysia. Under Article 19B, the Federal Constitution recognizes newborn foundlings as nationals of Malaysia, which is the state in which they are found. Also, once established, if a child is legally in a vulnerable situation as a foundling, and thus should acquire a genuine link to Malaysia as a national, or be protected against being left without nationality within 1 year of their birth. However, the problem is that the National Registration Department did not issue any administrative guidelines and procedures to implement the provision. Next, I'll pass it to one of my group members, Elise, to further elaborate on the cases relating about abandoned and foundling children in Malaysia.
And now I will be continuing on the statelessness and then children and families in Malaysia. I would like to talk about a case concerning a citizenship battle, the case of CCH against Daftar Besar Bagi Kelahiran dan Kematian Malaysia 2022. Appellants of this case was the adoptive father and mother of the child, CYM. It all started in January 2004. The appellants were informed by a friend that a baby boy was born and abandoned at a hospital at Cheras, Malaysia, and they had decided to adopt him and name him CYM. They believed that they had legally adopted the child and represented themselves as his biological parents. They completed forms and provided information to the authorities who issued them the child's birth certificate in February 2004. When appellants applied a My Card for the child, the National Registration Department (NRD) declined their request because they noticed the inaccuracy in names. The child's birth certificate was withdrawn later after an investigation by NRD and revealed that the applicants were not the birth parents of the child. Then they were requested to surrender the first birth certificate and were issued with a new birth cert. The second birth certificate stated the child's parent information as non-citizen and the child's citizenship status as yet to be determined. The appellants were dissatisfied with it and applied for an adoption order which can confirm that as the child's adoptive parents. The third birth certificate has several differences compared to the second one. The changes in the third birth certificate include the status of citizenship changed from yet to be determined to non-citizen. The color of the birth certificate changed from grayish green, which is for the citizen, and to pinkish red for non-citizen, which indicates that CYM still remains stateless. We can see the difference in both certificates of the citizens and non-citizens. Also, the status of the father and mother changed from information not obtained to CCH and NEY respectively. The courts noted that the respondent has the means to verify the identity of the child's biological mother, at least from the hospital admission records, since the child was born there. But they failed to prove that, so this made the application harder. The appellants appealed once more as they raised concerns about the child stated as non-citizen and effectively stateless. The constitutional provisions in this appeal is Article 14, Clause 1, Clause B, Article 31, and Article 19B. In this case, the appellants argued that the child is entitled to citizenship under Section 1, Clause E of Part 2 by Section 2, Clause 3 of Part 3, but failed. The courts held that in order to fulfill these requirements, applicant must show that his or her birth parents are not citizens of any country, and by word parents, it means biological parents and not adoptive parents. An appeal was made again, and after the case hearing, it was finally concluded that in the court's view, the child in this case is entitled to citizenship by operation of law based on the interpretation of Section 1, Clause A of Part 2 and Section 19B of Part 3. Section 19B applies in relation to children who are found abandoned in any given place, such as the place of abandonment, is treated as the place of birth and where their mother is also permanently resident there. We should also take note that if the abandoned children and families were not found exposed, the road to gain citizenship will be more challenging. In this case, since the child was found abandoned at Hospital University Kebangsaan, Malaysia, it is presumed that the child was born to a mother permanently resident in the Federation. The place of findings satisfied the requirements of jus soli, while the presumption fulfills the requirement of jus sanguinis by establishing parenthood. Therefore, the judge eliminates the need to consider whether the child was stateless or discuss other provisions of Part 2, and CYM is entitled to citizenship by operation of law under Section 1, Clause A of Part 2, read with Section 19B of Part 3. I will conclude by saying that citizenship by operation of law is a fundamental and constitutional right. It leaves absolutely no room for the exercise of subjective notions in what citizenship is. Imagine if the appellants in this case did not take the initiative to apply for citizenship and persistently appealed their case, the child would have remained in a state of statelessness indefinitely. It is evident that abandoned children and families like the child in this case deserve citizenship by operation of law. Additionally, it is important to consider that if citizenship is granted too easily or without proper scrutiny, there is a risk that more parents may exploit this opportunity and choose to abandon their children in order to secure citizenship for them. With that, I'll pass the presentation to Tiffany to talk about stateless adopted children.
Next, I'll be talking about statelessness adopted children. Malaysia do have our own law and act regarding adoption, which called Adoption Act 1952. The adoption parents need to undergo the respective procedure in order to legally adopt a child. The issue arises when the adoptive parent found out that even they have done all the procedures required, the child still failed to get a Malaysian citizenship. The Malaysia Adoption Act of 1952 did not address the citizenship of adopted children, and thus, nationality of the adopted children in Malaysia has been determined arbitrarily by the National Registration Department and ADI. So now, the question is that what should the adoptive parent do after they have registered for the adoption and become lawful parents for the child? They can apply for citizenship of the child under Article 15A of Federal Constitution. The Article 15A is special power to register children subject to Article 18. The federal government may, in such special circumstances as it thinks fit, cause any person under the age of 21 years to be registered as a citizen. So Suranjam, the lawyers of Liberty Advisor, said that Article 15A is of no use to stateless children as it is granted at the absolute discretion of the Home Minister. It has been a common problem that the applications under Article 15A take several years to process and frequently result in repeated rejection with no stated reason. Is there any other way to get a citizenship for those children? Let's dissect in the following case. In the case of Chu Chiang Huat against Pendaftar Besar Kelahiran dan Kematian 2019, the applicant adopted a child that has been born at the Hospital University Kebangsaan Malaysia. The identity of the child's biological parents are unknown. The applicants filed an adoption applications at Pulau Pinang High Court to formally adopt the child under the Adoption Act of 1952, and the adoption order was granted by the High Court. However, the status of the child stated in the new birth certificate is a non-citizen. Applicants apply for judicial review. The core issue here relates as to whether the adopted child has acquired Malaysian citizenship by operation of law pursuant to the articles in Federal Constitution. The applicants apply for the judicial review under the following ground. The first ground is under Article 14, Clause 1, Clause B, read with Section 1, Clause A, Part 2, Second Schedule. The Section 1, Clause A said that every person born within the Federation of Hosts, parent one at least at the time of birth, either citizen or permanent resident in the Federation. There are two prerequisites in this section. The first one, the child is born within Malaysia. Note that the child is born in Malaysia at the Hospital University Kebangsaan Malaysia, and thus this prerequisite is fulfilled. Second one, at the time of birth, the child parents want at least either a citizen or permanent resident of Malaysia. This prerequisite is unfulfilled for the following reason. The word at the time of birth refers to the biological parents but not adopting parents. In the case of Pendaftar Besar Kelahiran dan Kematian Malaysia against Pang BC, the Court of Appeal held that it is not sufficient that a person was born in Malaysia. He must be a person whose either parents was a citizen or permanent resident of Malaysia, and that provision does not contain any reference to an adoptive parent. The court further held that the adoptive parent can never fulfill the second prerequisite stated above, and this is because there is a factual impossibility as any adoption comes only after the birth, not at the time of the birth. Based on the principle of stare decisis, the High Court have no reason to disagree with the decision of Court of Appeal in the Pang Siwi case. There is no way to ascertain the biological parents of the adopted child, and this because the child falls into the category of stateless. The second ground was that under Article 14, Clause 1, Clause B, read with Section 1, Clause E, Part 2, Second Schedule. Section 1, Clause E state that every person born within the Federation who is not born a citizen of any country, otherwise than by virtue of this paragraph. This provision is to be read with Section 2, Clause 3, Second Schedule of Federal Constitution, which reads, for the purpose of paragraph E of Section 1, a person is to be treated as having at birth any citizenship of which he acquired within 1 year afterwards by virtue of any provision corresponding to the paragraph C of that section or otherwise. There is no dispute that the child is born in Malaysia. The issue here is whether the child was not born a citizen of any other country. In the case of Tan Siew Beng against Ketua Pengarah Jabatan Pendaftaran Negara 2017, the Court of Appeal held that the phrase was not born in a citizen of any country refers to the relationship of the child to his biological and lawful parents at the time of birth. Since the identity of the child, lawful and biological parents are unknown, it is impossible to determine the lineage of the child that would enable him to be conferred citizenship by lineage. Next, I'll be passing the presentation to my group member, Waish.
Now we will be looking at a case where one of the parents is a non-Malaysian citizen. The case of Samuel de Racing and Pendaftar Besar Kelahiran dan Kematian in 2019. First, let's look at the facts briefly about this case. The first plaintiff is a Malaysian citizen and the second plaintiff is a British citizen, and they are legally married. Both children are born in Malaysia to mothers who are non-citizens and non-permanent residents of Malaysia. They are the citizens of Philippines. These mothers were given the pre-adoption birth certificates under the Births and Death Registration Act 1957. Both mothers decided to give their children up for adoption to the plaintiffs who are legally married. The biological mothers had statutory declarations to renounce their rights as the biological mothers. Now, these children are legally adopted by the plaintiffs under the Adoptive Act 1952. In the process, the plaintiffs were told to surrender the pre-adoption birth certificates to the defendant, and the defendant was told to issue new birth certificates, and these are known as the post-adoption birth certificate. Both the adoptive parents are now legally termed as father and mother on the new birth certificate. However, the children's citizenship was stated as bukan warga negara, which means non-citizen. The plaintiffs brought this issue to court. They applied the following declarations and orders. There are 3 declarations, the first being, the adopted children are citizens of Malaysia by operation of law, by the virtue of their birth in Malaysia, based on Article 14, Clause 1, Clause B, and Section 1, Clause E, and Section 2, Clause 3 of the Second Schedule, Part 2 of the Federal Constitution. The second declaration is that the children are Malaysian citizens by operation of law by lawful adoption, based on Article 14, Clause 1, Clause B, and Section 1, Clause A of the Second Schedule, Part 2 of Federal Constitution, read with Section 9 and Section 25A of the Adoptive Act 1952. The third declaration is that the children's birth certificate issued by the defendant under the Adoptive Act 1952, which is registered as bukan warga negara, is the unlawful violation of the children's rights as citizens of Malaysia. The order of mandamus suggesting the defendant to reissue the birth certificate and state that the children are citizens of Malaysia. So there are 2 main issues for this case. The first is a child who is born out of lawful wedlock in Malaysia to a mother who is a non-citizen and non-permanent resident of Malaysia but a citizen of a foreign country, be a citizen of Malaysia. The second issue, illegitimate child of a non-citizen and non-permanent resident mother of a Malaysian citizen by operation of law by virtue of birth in Malaysia or by virtue of the child's legal adoption by a legally married couple where the husband is a Malaysian citizen. Following this, the court has to make a decision based on the following statutes. Section 25A, Clause 6 of Adoptive Act 1952, Section 9 of Adoptive Act 1952, Article 14, Clause 1, Clause B, and Section 1, Clause A of Second Schedule, Part 2 of Federal Constitution, and the Article 14, Clause 1, Clause B, and Section 1, Clause E, and Section 2, Clause 3 of Second Schedule, Part 2 of Federal Constitution. The judge found that Section 9 of the Adoptive Act 1952 does not deem that an adopted child is a child born to the adopter in a lawful wedlock. The legal adoption of an illegitimate child is not qualified for citizenship, regardless of whether the husband of the legally married adoptive parents is a Malaysian citizen, based on Article 14, Clause 1b, and Section 1, Clause A of Second Schedule, Part 2 of the Federal Constitution. Being born in Malaysia does not automatically qualify an illegitimate child for citizenship based on Article 14(1)b and Section 1e and Section 2, Clause 3 of Second Schedule, Part 2 of Federal Constitution. To be eligible for citizenship, one of the biological parents have to be a citizen or permanent resident of Malaysia. The child must not have acquired their citizenship from another country within 1 year from their birth date, based on Article 14(1)b and Section 1, Clause A of Second Schedule, Part 2 of Federal Constitution. The post-adoption birth certificate under Adoptive Act 1952 does not prevail over the pre-adoption birth certificate issued by the Births and Death Registration Act 1957. As a conclusion, the court came to a decision that both children are not Malaysian citizens by operation of law, either by virtue of birth in Malaysia or by being legally adopted. The second decision is that all the declarations and orders applied by the plaintiffs have been dismissed accordingly. Next, I will pass it on to Singh.
I'll be talking about the difference between Article 14 and Article 15A of the Federal Constitution. On Article 14, subject to the provisions of this part, the following persons are citizens by operation of law. That is to say, every person born before Malaysia Day who is a citizen of the Federation by the virtue of the provision contained in Part 1 of the Second Schedule. Every person born on or after Malaysia Day and having any of the qualifications specified in Part 2 of the second schedule. Most Malaysians acquire citizenship by operation of law under this provision. When all the conditions are satisfied, the individual is automatically a citizen. There is no room for discretion by the authorities. And on Article 15A, subject to Article 18, the federal government may, in such special circumstances as it thinks fit, cause any person under the age of 21 years to be registered as a citizen. So what constitutes to special circumstances under Article 15A? This is not defined. However, in 2016, the case of the M. Naveen, although it is unreported, could be said as a guiding criteria of Article 15A. This is indeed a significant moment for child rights in Malaysia, in line with the spirit and intent of the said Article 15A, whilst upholding Malaysia's obligation under Article 7 of the United Nations Conventions of the Rights of the Child on the right of every child to acquire a nationality. The following four considerations, which were specified in the Court of Appeal order to guide the Home Ministry when evaluating an application made under Article 15A of the Federal Constitution, namely, the person is under the age of 21 years old who has no parents, the person who has a connection with the country, cases that would result in hardship, and also the best interest of the child. Applicants who have submitted similar Article 15A applications for citizenship have been told that a decision will be made in 2 years, where a personal non-guarantor who is placed in an extraordinary vulnerable situation, deprived of fundamental human rights, education, and subject to abuse. The government should act immediately to reduce the decision-making process and establish policies and legislation to relieve the human misery caused by child statelessness. To sum it up, Article 14 is slightly more straightforward and clearer than Article 15A because the term special circumstances is not specifically defined. So, in the conclusion, according to recent cases that have been elaborated above, the current situation of statelessness applying for citizenship in Malaysia is slowly changing to a better position. Although it is impossible for us to refute the truth that if a stateless child could easily obtain citizenship through a straightforward process where anybody who applies could benefit from it, it will open a floodgates for the courts and also result in an influx of abandoned children lying on the street. They do, however, have their rights. Listed below are the rights we as Malaysian citizens may enjoy while stateless people cannot. So the first one, education for stateless children. While there are non-government organizations that have developed a number of secure spaces for these children to learn maths, language, music in a variety of methods, most doors remain entirely locked and there is no way for them to pursue their future ambitions. Stateless children, through no fault of their own, are born into the world which they feel they will face a lifetime of entrenched discrimination, disappointment, and rejection. And second one, on the opportunity and employment for the stateless. The right to lawful work is denied to the stateless in Malaysia. In extreme times, stateless communities must sacrifice their dignity in order to survive. The biggest sadness is when stateless children are not given the opportunity or freedom to shape their own future. And the third one is on healthcare for the stateless. Non-citizens pay extra for healthcare in Malaysia, which implies that foreigners, including stateless and undocumented persons, must pay more for consultation and medication at local clinics and hospitals. Stateless populations are at high risk of ill health due to a lack of access into government clinics and hospitals. Communities in more remote locations may also find it difficult to access local government healthcare facilities. And the last one, on the protection from abuse, trafficking, and exploitation. Children who are stateless are vulnerable and can easily fall into the traps of forced work and financial bondage. Without evidence of age, stateless minors are sometimes charged as adults. Statelessness is a complex issue that spans several generations. The effects of statelessness on people are profound. Communities as a whole, as well as whole generation, may be impacted, but with enough governmental will, private goodwill, and public knowledge, we can all work to restore the worth and dignity of this group. They deserve to be recognized because they are human just like you and me. So that's the end of our presentation. Thank you.
Hello, are you free? Can I ask you some questions about statelessness?
Can, but I only have about 5 minutes. Is it enough?
Yeah, sure. It will be a quick interview. Okay. So, do you know anything about statelessness?
I think statelessness is referred to the individual who do not have any citizen of national in any country.
So, moving on to the next question, what do you think about stateless adopted children?
I think the problem of the stateless adopted children is because most of the parents that did adopt the children will now doing the legal adoptions procedures, and moreover when there is no threat of biological parents, the children will be considered as stateless. The parents do this because they do not want their children to know that they are adopted.
So, do you think that stateless adopted children can apply for citizenship?
Sorry, can you please repeat your question one more time?
I'm asking about the stateless adopted children. Do you think they can be a citizen of Malaysia?
Okay, from what I know, the children are allowed to apply for citizenship. However, National Registration Department often issue the adoption certificate of birth certificate stating the children as not citizens of cannot be determined. Adoptive parents are asked to apply on behalf of the children for citizenship, but usually they are rejected. After the children turn to 18 years old and above, there is no avenue for him or her to apply under any article, even though the form mentioned that it is applicable to children 21 years old and below. To remain in the country, they are asked to produce passport instead, and this is high-risk reality for statelessness adopted children.
So, what measures do you think can be done to prevent statelessness in Malaysia?
I think the parents should be aware and also do apply for their children's citizenship, and also the parents should register marriage according to the Malaysian law.
Okay, thank you so much for this interview.
Thank you.
Thank you for your time.
Hi there, I'm doing a quick interview on statelessness. Do you mind if you do some sharing on this?
Okay, no
It can
problem.
only take a few minutes.
Okay, no problem.
Thank you. Do you know anything about statelessness?
Yes, I think being stateless is like a person who do not belongs to any country and therefore they do not have legal rights or protection that citizen will have.
Okay, cool. Do you think that statelessness exists in Malaysia, and what's your opinion on that?
I think yes, there is probably a lot of statelessness in Malaysia. I mean, there are people who don't have citizenship or some legal documents, right? That's basically what statelessness is, I think.
Okay. So, do you think that an abandoned newborn child should be a citizen of Malaysia, and why?
In my opinion, I think yes, because a newborn child is completely innocent. It's just unfair to punish them for not granting them citizenship due to the action of their parents. So as long as the child was born in Malaysia, they should be entitled to Malaysian citizenship based on the just value principle.
Okay, so the next question is, how much do you know about the stateless adopted children?
To be honest, I have only heard a bit about the issue of stateless adopted children in Malaysia. I think it is quite heartbreaking to think of these stateless children growing up without being able to have access to basic service, for instance, education or healthcare. I think the government must take responsibility on this stateless issue to ensure that all children have a legal identity when they are born, hence have access to service like all other citizenship.
Okay, so the last question is, what measures can be taken to prevent future cases of statelessness?
In my opinion, there are many measures that could be taken, such as creating awareness. That is removing discriminations, simplify citizenship laws, so that people stateless could understand what are needed to do in order to gain citizenship.
Okay, thank you so much.
Hello, I'm a student from Taylorsuniversity, and then I want to do an interview for you regarding the statelessness occurred in Malaysia. Do you free now?
Yeah,
Okay. So the first question that I want to ask you is that, do you know anything about statelessness?
Yes, it means a person without any nationality of any country.
Seems like you have a little bit understanding of that. So the second question is that, do you think that statelessness exists in Malaysia, and what's your opinion on that?
I think it does exist in Malaysia, but much of us don't know about it in details. Maybe the children, we see them begging by the roadside, they are statelessness child, or maybe they are at high risk of statelessness.
Do you think that an abandoned newborn child should be a citizen of Malaysia, and why do you think that?
I do think that this degree of matter should be discussed. If they can get a citizenship easily, I think we will see so many abandoned child along the street, and this is definitely not the case that we want to see. But in another way, if it's too hard to get a citizenship, their living standard will be so bad.
Okay. So the question number 4 that I want to ask is, how much do you know about stateless adopted children then?
I think this issue arises because the parents don't really know about the procedure needed to adopt a child.
So it means that you think that they don't know the procedure, so they just simply adopted the children, but then they didn't have a correct procedure so that the adopted children will be a statelessness in them.
Yeah.
So what do you think what measures can be taken to prevent future cases of statelessness?
So what is required is a political will. States need to set up a stateless determination procedures as a regularization route for stateless people who would otherwise be stuck in indefinite limbo. And then all stateless people should be granted a resident permit upon application for stateless status. A route to permanent residence should be granted when recognized as stateless. And this should provide a clear pathway to facilitated neutralization so that stateless people can resolve their statelessness.
So it seems that you think like the government should have a bigger responsibility in resolving the statelessness issue.
Yes.
Okay. Thank you. That's all for the interview session. Thank you for your cooperation.
Hi, sorry to bother you. Do you have a minute?
Yes.
Okay. So I'm gonna ask you some questions about statelessness.
Uh-huh.
So, do you know anything about statelessness?
Yes. I mean, it refers to the person who doesn't have any sort of citizen at all, and being stateless means that you have restricted rights compared to what a citizen would have rights to. This might make some of the stateless people who have no access to a lot of things like education and job opportunities, and therefore I believe life becomes harder for all of them.
So it seems like you know a little bit about statelessness. So next question, do you think that statelessness exists in Malaysia, and what is your opinion on that?
Yes, I believe statelessness definitely exists in Malaysia, just as it does in any other country. There are a number of reasons as to why statelessness exists. For example, parents who have an unregistered marriage will make it difficult for their child to get a citizenship. Children who are abandoned at birth as well become stateless.
So following question, do you think that an abandoned newborn child should be a citizen of Malaysia, and why do you think so?
I believe a newborn child doesn't decide if he or she wants to be abandoned, nor do they ask to be abandoned. This is why I believe that an abandoned newborn child should be given the citizenship in Malaysia.
Next question, how much do you know about stateless adopted children in Malaysia?
I believe statelessness is not uncommon among the adopted children. This especially applies for those who are found abandoned at birth. I believe it becomes difficult for parents to adopt because of the statelessness being a big issue.
Okay, so last question, what measures do you think can be taken to prevent statelessness in future cases, or like future scenarios?
I think spreading awareness about statelessness can be very helpful, and since a lot of people have little knowledge about it, the family planning should be also help ensure that a child won't be born stateless.
Thank you so much for your time.
My pleasure.
So hi, feel free for me to do some simple interview.
Okay.
So I'm going to ask you about something about statelessness. So do you know anything about statelessness?
Yes, I do. I know that it belongs to those who do not hold citizenship in their country.
Yeah.
Okay. So do you think that statelessness exists in Malaysia? And what's your opinion on that?
I think that statelessness, right, does exist in Malaysia. Because last year I went to Sabah and I saw a number of children living in terrible circumstances, and they had insufficient sanitation and no effective waste management, and this will result in waterborne infections and skin problems maybe.
The question 3 is about, do you think that an abandoned newborn child should be a citizen of Malaysia, and why?
For this question, I actually have a neutral viewpoint when it comes to this issue. The main reason because of this is I realized that how difficult and expensive to raise children who is stateless, and we as a citizen is unable to enjoy many things that a citizen is supposed to do lah. However, granting abandoned children the right to citizenship would undoubtedly open the floodgates to Malaysian courts, and there will be an influx of abandoned children. Yeah, that's my opinion.
Question 4 is about, how much do you know about stateless adopted children?
So according to what I know, there are 2 legal systems in Peninsular Malaysia that allow for child adoption. The court will refuse to give an adoption order if a solitary male applicant applied to adopt a female child, or if it is discovered and that there is a monetary interest involved in contemplation of the adoption, save in cases where the court may authorize it. And the natural parents or guardians of the child must have consented to and maybe understand that the order has the effects of vesting in the adopter all rights, responsibilities, obligations, and maybe liabilities of the adopted child, as if the adopter had given birth to the child in lawful marriage. Yeah, that's all I think.
The last question is, what measures do you think that can be taken to prevent future cases of statelessness?
In my opinion, maybe by encouraging the possession of a nationality, or maybe can raise the awareness of statelessness, or identify population of the stateless. Yeah, and individuals' nationality might provide them a sense of like identity and give them the access to a number of privilege. Yeah.
Okay, thank you.